Please introduce the submission and those that you would like members to take into consideration before the decision, including those that you can provide some clarity. Questions.
Thank you, Chairperson. I will introduce the tariff for GTA 3 or the loop line 2. It is for the period of 1 January 2021, December 2025. The application was necessitated by the fact that required the volumes that are enabled by the loop line 2. ROMCO is applying for the tariff. Chair, ROMCO is also applying for a distance-based tariff. It is for the tariff for the volumes that are transported from Rossano Gracia to Secunda. And lastly, the volume. Chair, in our assessment, we had differences with ROMCO such that made the tariff between NERSA and additional volumes that are coming from population. The second difference is or everyone that uses the volume and not necessarily did not follow the tariff guidelines in submitting is up with the tariff guidelines in capital and also the calculation on the basis of the distance-based tariff.
Thank you, Chair. With regards to the tax calculations are very material. And from a principal perspective, firstly, the calculation of the tax, according to the tariff guidelines, are that the tax based on the return as per calculated between the base and the cost of capital itself. And ROMCO's theory of that, so they are derived from actually an approximate calculation of a tariff or a target tariff, and then they multiply that by their targeted volumes. Is the fact that there's also another element which is a wear and tear, and so that residual amount that from a depreciation perspective it's actually given that you understand that the period is half, so that way, to the tax calculation. And then from a volumes, in a net working capital perspective, the also perspective, ROMCO believes that given that where net working capital is part of the RAB, that for them to be compensated given the timing of the RAB, that it's over a longer period. However, according to the tariff guidelines, the net working capital is a cost that we allow for a short period, not for a period over 12 years. So it's overall for your operations to be able to cover your operational expense. Indexing it by inflation, we believe that it's actually over itself. And then the next item is the volumes. ROMCO is of the view that there is actually an extra 2% that they would be receiving. They're coming from a distance which is just under halfway on the pipeline. We haven't included those extra 2 petajoules. And from a tariff perspective, we believe that also from a tariff guideline perspective, we believe that those petajoules should benefit the whole of the consumers who are using the major material differences. They had changed the capital structure of ROMCO to reflect what the current events are. However, the project itself, the initial funding was funded at a different capital structure. And given the debt portion has been paid by equity, however, from a project perspective, so that there is no over recoveries, and so that there is no over or under recoveries as a result of that. I think that in a nutshell. Thanks.
Thank you very much. Anything to add, Mr. Kotora, as Ms. Makot?
Yes, I think most of the issues have been covered by my approved tariff is about 59 rands. And the current application is for about 72 rands, which is about a 22% increase. So given that these differences we have in this tariff application, we have decreased, Chair. I think that is the only issue I wanted to, that when ROMCO applies next for its tariff for a loop line 2 as a standalone, and if they want to use section 22 to structure their tariffs, it should be a separate application, a separate section of the application where they show how this structuring is done, and no a composite tariff which includes section 22 in one figure. And see, to show us costs that vary with distance and costs that don't vary with distance. Share some of the costs, like tax, is being split on a 45 to 55 is allocated to the Mozambican side, whilst 55% is allocated to the South Africans. Distance-based tariff, they are using the length of the pipe such that principals would want, if they are divided by volume, if you what they use to allocate costs should be the same that is used if the colleagues have said, Chair, thank you very much.
Check if members have any questions of clarity, guidance with respect to this submission. Members, by show of hands, if you have any questions of clarity. Mr. Mkize, you can go.
Thank you, Chairperson, and thanks to the presenters. I note that this submission was to this meeting, and with incremental tariffs, GTA 1, GTA 2, GTA 3. I would recommend that we also look at the aspects that are the policymaker and government to assist in addressing this matter. Because I don't think that a molecule of gas passing through this, whether it's loop line 1, loop line 2, or when a person joins later on, and for appreciate if the team can kind of workshop us on the approach post the decision of today, on the approach really to be taken, looking at the pros and cons, and we cease to have the kind of challenges that
have any input on this by show of hands, members, if you do. If not, then to the recommendations. The recommendations, the page for the recommendations, so that we read them for the record.
Trying to get to the page.
All right. In terms of the recommendations, yeah, that is because your document is not numbered. Anyway, so the recommendations are on paragraph 63. Paragraph 14 of the document, we're 3 to 103 until December 2025. The other decision that is requested is that the PGS must recommend to the regulator to not, I don't know why then, I think we need to amend here. Part is the decision to not approve. That's the recommendation. The second one must then to approve the reasons for decision. I think it's just the writing there that was just confusing. And then the third one, for no challenge in implementing tariffs effectively, if there could be a workshop or an approach in terms of determining. May you please then show by raising your hands, please. Thank you, Advocate Sithole. And thank you, Mr. Mkize and Mr. Gumede. I also support. You've got the period starting 1st April 2023 until 31st March 2026. Please, key issues and concerns.
And this is for the pipe gas pipeline from Secunda to Durban South. The application is for the tariff for the period of 1st of April 2023 to 31st of March 2020, for a tariff of 11 Rand 14 cents per gigajoule for the period of 2024-2025. And lastly, they are applying for the tariff for the period of 2025-2026 that we would like to highlight regarding this application. And the first issue is relating to the volume. Chair, in the previous determination, NERSA was concerned about the volume from previous application, and therefore we believe that these volumes for 1% increase, we will also audit them as part of RRM to make sure that we deal with differences if there is any difference in case if Transnet is not able to achieve these volumes. Due to the 2012-2013, NERSA approved as application. There is a latest study that was done by Transnet, and the study was done by the reasons for this study and also our assessment perspective. Ms. Mhlongo.
Thank you, ma'am. Thank you, ma'am. Chairperson, the after assessing their decommissioning provision in 18 value, and Chair, according to Transnet, the increase was informed by the latest study conducted in 2020-2021 financial year to this excessive increase, as well as to assess the reasonableness of the study. And Chair, we found that cost was mainly driven by additional activities conducted to comply with and to assess both to assess the decommissioning in both studies. It was based on an on-site visit, hence more activity in that new study. Chairperson, we have further sent both studies to engineers at GLC department to provide us with their and yeah, thanks, Chair.
And the members and the colleagues. When we look at the documents, they submitted two methods. The first method was on the desktop study, and the second method was we tried to compare the two methods, of which it is not recommended from the technical point of view, because the desktop study has some shortfalls in terms of the other study, which was the more physical that are covered by the second study are more realistic compared to the benchmarking that we did. That we did was for and one from Kuwait. The two benchmarking, when you look, because they are more closer to reality. Thank you, Chairperson.
The submission is before you for consideration and questions, and can engage with it. Thank you. By show of hands, members, if you have questions of clarity. Advocate Sithole, I'll start with you. Thank you.
And thanks to the presenters. Chair, mine is just one issue of clarity which relates to for stakeholder comments. And it seems as if we are saying that they were to be included in the submission. And when I read it in terms of verbal, it then say that there were no public hearings because there were no presenters. So I don't know whether the presenters in public hearing, is it just a matter of trying to ask the team to enhance the paragraph that talks about this, to say that both comments, oral and in writing, were not received, and therefore then there were no public hearing. The team can just clarify that. That is on paragraph 8.2 on page.
The matter that Mr. Zwane on, with respect to paragraph 5.37, does this then still say, in terms of what I've heard from Mr. Zwane, does that statement then still hold of doing or delaying the adjustment to a later stage? And if the latter part is said to be more realistic in terms of the comparison with the benchmark study that was done previously. We then revisit that to smoothen. We rather be looking at that instead of disallowing. I just want to get clarity there. Thank you.
Thank you, Mr. Mkhize. Ms. Makota and the team, please respond, and I don't want to repeat them here because I've already provided guidance to the team because we did not subject this study and thoroughly assess it the way that we have done the previous one. And there was no of any shortfall in respect of be adjusted by inflation to keep up with the value 1,000% increase on, and no such assessment was done on whether the cost that you allow regulations guide us and prudently incurred. In this instance, no such assessment was done. It's something that was submitted with the application, and hence then there was that statement that Mr. Mkhize raised there. It will be disallowed to give the regulator time to conduct an assessment on the efficiency test as well as the prudency test on such cost of the Gas Act, which prevents any excessive pricing of tariffs. Please respond.
Any written comments as part of the public consult? In terms of there were no comments received, and also the public hearing could not take place. Mr. Mkhize's input on paragraph 5.37, Chairperson yourselves, that we need to thoroughly undertake verification or do a reasonableness on the information that is provided by the applicant. Now, it was noted by Kentley, and we then forwarded the information to the licensing so that they can assist in determining whether the activities that are included are reasonable. And that is the results that Mr.
Mkhize,
the document, I was happy with the recommendation based on the study having not been conducted. Now, with what has been found preliminary in terms of the study, would one then, based on what was explained verbally, is what then brought confusion on my side, is to say, I just would like to get like maybe should it change it? Shouldn't we then maybe, if it can be finished within or days, that we await that outcome before maybe getting?
The team can respond. The only thing, remember, they are coming up. The team did not do efficiency test. The team did not do. Our regulations requires of us to do that. That's the only thing that we must do, at least for a proper decision. So that is one thing. So they cannot stand and say this has been done. So because in that you can say overnight, this must now be included here. And also there is no risk to Transnet, even if the issue of an adjustment or a clawback can be done later, to give, I believe that this cost that must be added, then, or maybe a portion of it, then it will be allowed in the next review, because no efficiency test and no prudency test was done. So that is the basis. The second basis is the whole issue of allowing a cost that over 1,000%, 1,000%. Again, there is no economic here that something like that will not be tantamount to increases as contemplated in Section 31 of the Gas Act. So that's another element that the team still needs time to work on it. It didn't, because it's a whole exercise that they need to focus on. So that is the second basis here, because it will be of allowing a cost increasing with more than 1,000%, especially because for the past 10 years or 14 years, There has never been a situation where Transnet has come to the regulator and say, the way that they have been doing this, there was it caused a shortfall. Now, the energy regulator must investigate where this huge amount is coming from. And that is coming from changes in legislation, but it doesn't link that up. So those are the key for investigation of prudency and efficiency. And I've said dialogue. But, you know, in terms of when I was looking at monitoring and approval, to say that now when you approve, you can then decide not to approve a tariff. So I was not so sure whether, because one would look at how long maybe this would take and then have a situation where you've been finalized. It will then be incorporated in the next tariff application or soon thereafter. But if it's a shorter time, then maybe the best would be to say incorporated, you know, that which has been verified. So that is for both the in terms of the regulator as well as the licensee, or just what I was trying to made by Mr. Zwane around looking at the
response and also take guidance. We considered the first option was indeed to delay of the application until we finalize the verification. This will take us off the timelines that are prescribed by NERTO, rather because these costs are not going to be used now, is for the future decommissioning provision, to rather ask Transnet while we submit a new application while we are dealing with this, and Transnet can then include that. More transparent than the other one, in that we clearly state to Transnet that this is what we think to do in terms of the study. Same process as we've done in 2012 regarding the Arthur D. Little study. While in the meantime, we process your application, excluding the diction. Tim, I may not have answered specifically, but I wanted to indicate.
Like you allow the cost that was allowed last year with inflation. If you do so, if you don't allow then of the range that we normally consider as the regulator, will there be? That's what that's what will take the members to a decision.
Okay, thank you for what we did in our own assessment. If we disallow the decommissioning provision, then which is accepts. So when you look at the NERSA's calculation, it takes the previous decommissioning and then add inflation as per what is 30%, and it's huge, which means then that Transnet will have to amend their tariff application as per our NERSA's procedures.
Thank you. Members, it's not time that we are stuck on the decommissioning. Transnet has done this in the PPR, and we had to look at it, and some exercises were done. Now, for the first time in gas, in more than 14 years, after the PPR one, we're now confronted with such a drastic increase. Remember that there's one account, and the decommissioning that was done in the past 5 years, it was from the PPR, and there is one account. So that there, because it's one division there, whether it's used for a gas related or own. And now look at the result. If the 1,000 and something percent is not allowed, look at the impact that it has now on the users and unfairness of the price, and the efficiency as well as the concern, than to just allow those things that will have a huge impact on the final result of the tariff of efficiently and prudently incurred. So I would like to then, members, if you can then get to a point of a decision where the cost, it is stated that the cost is not allowed, so that that cost be disallowed to enable the energy regulator to do a proper assessment, because the cost that is impacting on the final tariff is way above 30%. Members, are you comfortable that we then proceed with the recommendation as indicated? Okay. Recommendation, if there's no further input from the members, the recommendation
is with the increase, and then without that increase, maybe to use the other too little inflation. What does it come out to?
Can you please do the and Mr. Njezula, can you please provide, in the meantime, I'll come to Mr. Tol, inflation, to adjust it with inflation for fairness purposes, without to now allow Mr. Sitole to one of last year adjusted with inflation. Okay, I note, Ms. Sitole. Thank you.
Yes, I wanted to show the tariff which use the last year's calculation and add inflation. It comes to R8.53 per gigajoule in that year, and then for little provision and adding inflation, and the differences there of 31.29 is due to the new study that was conducted.
All right. Members, you can see for yourself again. I think it takes us to the same thing. Remember our powers on the final tariff. As you can see, the differences on the table there, varying from 31%, regulator can overlook, especially if the work of looking at the efficiency test and prudency test is not. So either way, even if this you take it will still require the energy regulator get to the decision, please.
Yes, I apologize for this. Chairperson, I just want to include it as part of the petroleum tariff application. They do an annual tariff. It was included in the previous year, and NERSA took a decision to accept, wanted to bring that. Thank you, Chair.
For that it be that users must now be liable for something that they did not cause. So that was the decision there. So taking you to the decision 16, it is recommended that the PGS subcommittee recommend to the energy regulator not to approve Transnet's transmission application for the period 2023-24, 20 years. And then the second decision requires members by show of hands, if members agree to the two decisions required. Members, we then step out of this item, going straight Eliza gas for the transmission.
Chairperson, Ms. Mhlongo will introduce the submission.
Eliza gas is multi-year application for transmission tariff for the period 1 March 2022 and the tariff application. Now, Chair, the difference between Eliza gas calculation and NERSA's assessment is 5%. This is the REB, the weighted average cost of capital, working capital, and the OPEX. In terms of the REB, Chairperson, the differences are due to NERSA. The differences are due to the timing of obtaining data, and NERSA used the latest available information in calculating. Now, in terms of the working capital, the differences are due to Eliza calculating first year and then escalating the figure by inflation, whereas NERSA recalculated the required working capital, excluded funder-related cost expense, as it amounts to double counting, since this cost would already in the return portion of the tariff. Chairperson, as mentioned before, the overall difference between the calculations is 5%, and as it has been NERSA's practice to accept difference in the publication of the reasons for decisions. Thank you.
Thank you very much, Mr. Keswa. Members, the comment guide, if you have any comments, by show of hands, members. Okay, if there are no comments, it's straightforward, members. I would like to take you straight to page 6. The recommendations are on paragraph 16. The pipe gas subcommittee, Eliza Gas's application for a transmission tariff for a period starting March 2027, February 2032. To note that the decision of the energy regulator is effective on the day that in terms of the prescribed formula in the regulatory agreement. Please introduce and indicate the differences and the reasons for the change.
As you've said, this is a report that we do every quarter. ROMCO's GTA1 tariff in line with the two governments. ROMCO was compliant, and over and above, therefore, we request PGS to note one tariff. Thanks, Chair.
Thank you very much here for noting. Any question on page 8? The ROMCO GTA1 tariff of 20 rands 34 cents per gigajoule per annum for the period part of the decision required. By show of hands, members, if you then support that decision. Thank you, Mr. Gomede. Thank you, Mr. Mkize. Advocate Sitole, thank you. It is the report on the complaints and those that are before the competition authorities, as well as areas of overlap and what is the approach that has been taken in handling these complaints. Thank you.
Thank you very much, Chair. Chair, I will take the submission as read and just highlight the key issues. And I will also focus on pricing complaints against Sasol Gas that was lodged with the competition authorities by UGWASA, SLG, and Igoli Gas. Chair, the complaints centered around Sasol Gas's actual prices to its customers. The first aspect relates to the level of Sasol Gas, where it is alleged that these are excessive and that the significant increases that were anticipated have a detrimental impact on Sasol Gas's customers. The second part of the complaints, which were made by third-party traders, is around the fact that Sasol Gas had abandoned any discounts from the maximum price that it afforded to its customers in the past, at the maximum price approved by NERSA. We refer to this as Sasol Gas's uniform pricing approach. Chair, it's worth noting that NERSA has been cooperating and have had numerous meetings with the Commission since the very start of the Commission's investigation. Sasol Gas has refused to give to them. This will also be discussed further by David. Mr. Mashio also received similar complaints from SLG and Igoli Gas. The complaints centered mainly around Sasol Gas's uniform pricing approach, as well as Sasol's announcement in August 2022 that it would increase its customers' prices with almost 100%. Sasol Gas issued its notice to its customers in August 2022 of an impending price increase of almost clarify extensively that it did complaints lodged by SLG and Igoli Gas. In that, the methodology would not allow provision for a minimum discount to third-party traders. This would force Sasol Gas to allow for some discount to third-party pricing approach. Chairperson, we have also noted in the submission that there is an emerging forum shopping by NERSA's licensees in that they are complaining about the same conduct, with both the formal explanatory note setting out NERSA's reviews regarding the substance of the complaints at the Commission be prepared and submitted, specifically be relating to the current price of 68 Rand charged by Sasol Gas and why NERSA's of review. Chairperson, I will now hand over to Mr. Mashiane to take the meeting through the two matters that were heard by the Tribunal in February of this year and perhaps anything else that I may have missed in my introduction. Thank you, Chair.
Thank you, Ms. du Plessis. Mr. Mashiane.
As it was requested by the REC some time back, and the Competition Tribunal, by way of an application by IGWA SA against Sasol Gas for against Sasol to implement the 68 Rand price of gas, which has already been approved by NERSA. The argument by IGWA SA is that even worse. Therefore, the IGWA SA following lodge a complaint with the Competition Commission to investigate these the allegations of excessive pricing by Sasol Gas, and therefore they have applied to tribunal following that in the meantime the Competition Commission is still investigating the allegations of excessive pricing, then Sasol Gas should be interdicted from further increasing the NERSA. And subsequent to that, Chair, the law relating to Sasol Gas prices, because the tribunal does not have jurisdiction, and they should dismiss these processes, Chair. The Competition Commission, having been busy with the investigation of the alleged complaint of excessive pricing, they've also came in. We, as the Competition Commission, in terms of our empowering legislation, we do have powers to can investigate and the Competition Commission and NERSA. And following that, because the Competition Commission does acknowledge that a customer, in this instance Sasol, may be one regulator with such authorities like NERSA, and which for NERSA we do have that MOA with the Competition Commission to harmonize the issue of concurrency of jurisdiction in this matter. Going forward in terms of mitigating against the risks that may, what Louise also indicated to be forum shopping, or the regulatory, the statutory mandates which both these authorities do have, is to engage with the comment that the NERSA should always file an explanatory affidavit in all such matters, in order to formally filed by NERSA in response to that shall have been made by the license against or by the was heard by the Competition Tribunal on the 6th and the 7th of February, and the Commission on the last day, on the 7th, they reserved judgment. And so far we still waiting for
it. Must be the tribunal.
The tribunal, the ruling by the tribunal.
Acknowledge the risk of not being presented in such forums, especially at the tribunal, because if there was no explanatory note and NERSA was invited in those proceedings, and then the tribunal makes its own decision, and that decision might actually have powers of the energy regulator, because the competition authorities have jurisdiction on excessive pricing. We also have the same issue of that the same price is also before the High Court. So because it will be a very serious situation if the tribunal were to find that the price that Sasol charged is excessive. That then begs a question, and is something that could have been prevented, as those are some of the risks. Members, any guidance, input on this matter? I don't know which one came first. Is it, I think, Mr. Gumede, because it shows number 1.
That says, does the competition, number 2, which is a comment now, is that for me, although something may be, broadly indicated in the competition law, something that in terms of the high courts, even if they can, of course, something taking on review, can be reviewed. But if we don't guide our irrelevant, for instance, and this should be something that we do, whether it's a price other than that set or approved by the energy regulator, that we should actually guide that. The competition law, in answer to my first question, trumps all of that. That whatever decision by the High Court, for instance, can then replace our decision. I think it's something that for me, I honestly do believe that on this particular one, That is just a view. Is that a price or a tariff that has been approved or set by the energy regulator? Unless for further, thanks.
Thank you, Mr. Committee. Advocates,
in the Sasol matter. However, we did not submit our explanatory out as to what was overlaps with those of the energy regulator. So at that stage, at the CC level, before we even get to the tribunal level, NESA should have been really involved before the tribunal. Thank you, Chair.
Thank you, Advocates. Mr. Mkhize.
Thanks, Chairperson, and thanks to the presenters. Maybe any comments or guidance or questioning would be kind of limited in a way from my side. But what should come out very clear for me is the issue that was raised in the latter part by Mr. Kumede, and to some extent, what exactly was job, and then what was supposed to then follow from our side, that we do our part. That for me, I would like to get that clear,
because there were very clear marching orders, so to assist that process in understanding how we do things, what our powers are, so that we avoid now sort of be fighting each other, taking the tribunal to the High Court, and they interfered with the core functions of a sector regulator. So we don't want to get to that point. Can you please clarify?
Affidavit before the elaborate more on that, because even cooperating with the competition department within the division, and therefore we mission, and if it could be noted, the matter before the competition tribunal to request actually to guess from implementing the increase on the price of 16, and the IGWA SA further says that we are interdicted up until we seek an order for an interdict. Upper Commission has finalized the investigations of alleged excessive pricing, which in my own understanding, which Louise maybe can add on that, is that the investigation is continuing and the Commission is liaising with NERSA in that regard. Therefore, we still have can file those explanatory notes with the Commission. Is not yet lost. And the reason why we did not also, Chair, brief attorneys to file affidavits the competition tribunal was that, Chair, looking at the relief that was sought by IGWA SA, we deemed it not be necessary for NERSA to from Sasol to increase the price of 68 rand. And the third issue, which is also important to that effect, is that before the tribunal, the Sasol Gas has already made an undertaking necessary, Chair, and for us to mitigate the risk of NERSA. We did brief attorneys to on a watch brief about the in the competition tribunal. Thank you, Chair.
Members are this with, especially with the risk of getting deep into governance matters, but it's perhaps there seems to still be this growing confusion on what we can do when the matter is before the Competition Commission, and what we can do there. And we can participate in the proceedings before the Commission. The Act states that. And it is helpful when we take matters at that level before the matters go to an adjudicative body, which is the tribunal. And this must be very different between us and the Commission. And then with the tribunal has always been very diligent, even not only in this matter, in all other matters, So we just also from our side be cooperating, because we will fall short wherever we're going, where they state clearly they have approached us, and therefore we were not responsive. All right, can we hold on to this a part of the discussion, members, and just wrap it up in the closed meeting? Since it has just an aspect of governance, and then we can close on that aspect of governance, which will probably be realization of this item, so that we can deal with item 11 and item 12. Members, I have to get your indication. The volume balance report for March 2023. Please take the matter as read and highlight key issues.
Thank you, Chairperson. The purpose of this submission is to request the PGS Subcommittee to note for the month of March 2023. This is the last vote gigajoules of natural gas to the South African markets. The percentage variance for March 2023 was -8%, which is within acceptable limits of the agreed international benchmark. In the 2020 vote, Sasol Gas supplied 153 million gigajoules of 1%. The supply increased by 2 million gigajoules compared to the gas in 2022 financial year. This shows an improvement as it was expected. 7.8 million gigajoules less than the 168 million gigajoules per annum of natural gas expected in terms of GT1, GT2, GT3, and GT1, GT. So the reasons was the energy regulator expressed concern regarding a shortfall in the supply volumes of natural gas to the source of gas, and the yearly fluctuation of supply reasons, economic conditions, and the market which influence the volume supplied. For example, during the financial the limitations, 22 was approximately 147 million gigajoules. Level was expected because of operational delay that had to be suspended in 2020 due to COVID-19 pandemic and related travel limitations.
Please, Bishak, let's take the report as read.
And expectations that it is expected then that the PGS Subcommittee to note is also for balance report for the month of
for this financial. The recommendations are that the PGS Subcommittee is requested to note the volumes that were delivered in Secunda, is table 3. Thank you, Mr. Mkhize. Thank you, Mr. Gumede. I also support. Advocate Sithole, are you happy to support? Thank you very much, ma'am. All right, members are moving straight to, please take 2 minutes to introduce this one and indicate the significance of this calculation and where.
Thank you, Madam Chair. I'll take this submission as read and shoot straight to the point. The purpose of the update on the risk-free rate and the market risk premium calculation for the year ended 31st March 2023 as attached Annexure A. In a nutshell, the calculation and publication of MRP and risk-free rate is intended to address the request made by stakeholders that in order to ensure transparency and consistency in the calculation of the risk-free rate and market risk premium, publish this information on a regular basis. I would like to draw the committee's attention to focus on page 5 of market risk premium and the risk-free rate for the period ended 31, that the MRP declined by 0.12% and the risk-free rate are used in the calculation of the